A pleasant afternoon to everyone. Thank you for taking the time to join us here today in our workshop under the Clinical Pedagogy and Professional Ethics Cluster. I am attorney Josiah Bagayas. I am a law professor at the Mariano Marcos State University in Batac City, Ilocos Norte. And I'm deeply honored and thrilled to share with you my paper presentation entitled Recalibrating the Indigency Test Towards Ensuring Equitable Access to Justice and Legal Assistance. Now, pretty sure that most, if not all of us, are quite familiar with the best selling book and movie, To Kill a Mockingbird. And perhaps some of you here were influenced or inspired by the book to become lawyers yourselves. So, in the book, the protagonist, Atticus Finch, a lawyer himself, is quite a character. And one of the parts of the book that stood out for me is when one of the clients of Mr. Atticus Finch, named Mr. Cunningham, gave Atticus his farm produce as payment for some legal work done. And now Scout, who is the daughter of Atticus, asked his father, sabi niya, Dad, why does Mr. Cunningham give us food? So Atticus Finch, he told his daughter that the food that was being given to them by Mr. Cunningham is payment for some legal work done by him. Okay, and Scout asked his father, why does he pay food instead of money? And to that, Atticus Finch answered that it's the only way he can pay me. He has no money. Okay? So art indeed imitates life. Because here in the Philippines, just as in the milieu of the book, we are abundant, or the Philippines has a lot of people who are living below the poverty line. So this is attested by the most recent statistics. As you could see in the slide, in 2021, the Philippine Statistics Authority found that the poverty incidence rate in our country stands at 18.1%. Okay, so that roughly translates to around 20 million Filipinos who live below the poverty line. And as we could see and analyze the statistics, the poverty incidence rate slightly rose from 16.7% in 2018 to 18.1 last year, primarily due to the battering effects of the COVID-19 pandemic. And reality for most Filipinos is quite bleak when they cannot even put enough food on their tables. How could we expect them to afford the services of a private lawyer? However, in the Philippines, we have a dearth or scarcity of lawyers like Atticus Finch. Perhaps his species is endangered in our country. Now, let's take a look at the current state of access to justice and legal assistance in the Philippines. Our Constitution provides, particularly in the Bill of Rights, that free access to the courts and quasi judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. Further, in the same article, any person under investigation for committing an offense, uh, if he cannot afford the services of counsel, he must be provided with one. All right. So these twin rights of access to justice and legal assistance are enshrined in our constitution itself. However, it was found in 2018, the World Justice Project, an international civil service organization, conducted a survey consisting of 1,000 respondents in the Philippines to look at what is to quantify access to justice in our country. And they found that among the most common legal problems faced by ordinary Filipinos concern money and debt, so it stands at 11%, and housing as well, which stands at 13%. Okay, so this is indicative of the socio-economic dimension of the average Filipino's legal problems. However, the survey revealed that only 20% of respondents said that they were able to access legal assistance for their legal problems. And from that number, from the 20% number, only 43%, imagine, said that their legal problems were fully resolved. Okay, so that's around less than 10% of the total respondents. And the respondents also said that on average, it took them 7 months for their legal problems to be resolved. Okay, so that's quite a long time. But of course, that's shorter when compared to actual cases in court. And lastly, 22% of respondents encountered financial difficulties in finding the resources required to solve their legal problem. Okay, so this survey conducted by the World Justice Project is groundbreaking because it sought to quantify access to justice, which is as elusive as justice itself, right? Now, to effectively implement the constitutional rights to adequate legal assistance, the Public Attorney's Office was established as the principal office of the government in extending free legal assistance. And in 2021, under the accomplishment report of PAO, they were able to assist 9.7 million clients. Imagine that huge number. Almost a tenth of the Filipino populace were assisted by PAO. And aside from that, almost 800,000 cases were handled. But what I've seen is that PAO has quite a good winning rate, as you could see on the slide. 86.48 were favorable decisions in criminal cases, 74.04% in civil, 78.23 in administrative, and 81.8 in labor. Now, to complement the efforts of PAO, the Integrated Bar of the Philippines also has a National Center for Legal Aid and also has various legal aid offices scattered across its local chapters nationwide. However, we could still conclude that access to justice and legal assistance in the Philippines remains to be inequitable. And one of the factors that we recognized why access to justice is inequitable is poverty. That's why it is important that we should look at the root cause or one of the root causes why access to justice is inequitable. However, defining poverty itself is a difficult task. Okay? Arriving at a uniform definition has always been a perennial problem for governments, for policymakers, even for social scientists and ordinary people. Poverty, however, could be understood in its absolute and relative conceptualization. So, for the first one, absolute conceptualization of poverty refers to the deprivation of economic resources that are required to meet basic necessities such as food, shelter, clothing, whereas relative conceptualization of poverty pertains to the deprivation of economic resources required for dignified participation in society. So, absolute conceptualization uh, is concerned with the physical or material needs of people, while relative conceptualization is concerned with the psychological and social needs of people. With this two pronged approach to defining poverty, we could conclude that poverty is an amorphous and ever evolving concept. So, attesting to that fact is is that the World Bank just recently, 3 months ago, increased the international poverty line from $1.90 to $2.15 per day per person a day, taking into account several factors such as inflation levels and purchasing power parity of different countries. Now, having a cursory survey of our statutes, we could see that in our laws, an indigent person is defined as such. However, as would be discussed later on, an indigent person does not necessarily uh, equate to a poor person and vice versa. Now, our statutes are instructive that an indigent person is defined as first, any person who has no visible means of income. That's the first factor. And the second factor is that any person who has insufficient income for the subsistence of his family. However, this simplistic definition could invite disputable interpretations. As the first factor, it does not consider income from quote unquote invisible sources, such as regular remittances or allowances from family and relatives abroad, nor does it include income from informal sources from unregulated economic activities. As to the second factor, the concept of family subsistence varies widely. Why? Because some families could do with less income and they would deem that the income they receive is already sufficient for their basic necessities, while other families and individuals would require a much higher income for them to conclude that their needs are being sufficiently provided. Okay. Now, because of that conceptualization and definition of indigent persons in our laws, the Supreme Court, under the rules of court, has been utilizing the indigency test in determining party litigants who may be authorized to litigate as indigents. So the Supreme Court, in the rules of court, utilizes two criteria. So the first one is income level, and the second one is the value of property owned. So for the first criteria, a person may be considered as indigent only if his gross monthly income and that of his immediate family is not more than the amount double the monthly minimum wage of an employee. And as to the second, a person would be considered indigent if he does not own real property that has a fair market value of more than 300,000 pesos, as attested by the current tax declaration. And if both of these criteria are met, then that person would be qualified to litigate as indigent. Okay, so I'm sure all of those students here who are taking up CIVBRO or have taken up CIVBRO are already aware of this test. All right, but now the problem comes in: is is a poor person the same as an indigent person? But before that, um, another tier of qualifying a person as indigent or not. If one or both of these requirements are not met, then an applicant may still ask the court for authority to litigate as indigent on the ground that he has no money or property sufficient and available for basic necessities. Okay, so there's one case, the spouses Algura versus LGU of Naga, where it harmonized Rule 141, Section 19, as well as Rule 3, Section 21, that are both concerned with the indigency test, in that we must first apply, or the courts must first apply Rule 141 and then Rule 3. Okay, so that's clear. Now, uh, as I was saying earlier, a poor person is not necessarily the same as an indigent person and vice versa. Because there may be persons who are not actually poor but qualified as indigent litigants or indigent persons. And there may be actually poor people, okay, who did not qualify as indigents, mainly because they failed to submit certain documentary requirements for them to be qualified as such. No, that's the bone of contention in our workshop this afternoon. That's why there is a need to recalibrate the indigency test in the context of clinical legal education. Because at its very core, the purpose of the indigency test is to give the poor and marginalized sectors of our society a much freer access to legal assistance and to justice. That's why a rigid application of the indigency test by legal assistance providers, such as law clinics, may defeat this very purpose. Now, how do we recalibrate the indigency test? Now, let's look at the best practices from other legal aid providers. So, first one, we have the Integrated Bar of the Philippines. Under the rules specifically promulgated by the Supreme Court that would govern IBP's handling and acceptance of legal aid cases, the IBP utilizes mainly the means test and the merit test. And secondarily, it also considers other relevant factors when it comes to handling acceptance cases. So the means test is shares a similarity with the indigency test as used by the courts under the rules of court, in that the applicant may be considered as qualified for legal aid services by the IBP if he has no money or property sufficient or available for basic necessities. So technically, that's just a translation of the indigency test um, in the context of the IBP. However, the rule went further and included the merit test, in that um, other factors are considered when legal service will be in aid of justice and taking into consideration the interests of the party and of society. And as to other relevant factors, these include the proper administration of justice, the practice of law in a certain locality, the public interest involved, and the effect of legal aid to the rule of law. Right? So now, the Public Attorney's Office likewise has its own version of a recalibrated indigency test. Under its 2021 revised operations manual, we could see here that any person may be considered as an indigent person if, for those who live within the National Capital Region, if that person has a monthly net income. I will emphasize that it's net income and not gross income, as opposed to the rules of court, a monthly net income of not more than 24,000 pesos if he lives in NCR. But if he lives in cities outside NCR, the threshold is not more than 22,000. And if he lives in a municipality outside NCR, it is not more than 20,000 pesos. So these figures reflect the ever-changing costs of living that were taken into consideration by the Public Attorney's Office in coming up with a revised operations manual. Also, the Community Legal Aid Service rule, albeit it is currently suspended, the test for indigency, according to the rule, shall not be based on a set financial amount, but on the capacity to afford the services of counsel. Okay, so it emphasized that the indigency test must not purely consider the financial aspect alone. Now, what are the implications to clinical legal education? Of course, under Rule 138A, one of the purposes and the goals of CLEP is to deliver legal services and to promote social justice and public interest, especially to the marginalized. But before that, we have certain ethical considerations, whereby all lawyers who are involved in CLEP, as well as all law student practitioners, are bound to observe under the Code of Professional Responsibility. So, as a rule, lawyers and LSPs must make legal services available in an efficient and convenient manner, and must take part in efforts to improve the administration of justice and initiate law reform, and lastly, to deliver legal assistance to the needy without regard to one's status in life. However, there are certain exceptions under the Code of Professional Responsibility, whereby law clinics could decide to decline to represent certain clients. So these are for serious insufficient costs. That's one. Second, if the law clinic is not in a position to carry out the work effectively or competently. And third, if there are conflict of interest, right? So having these ethical considerations, we now go to the two issues and challenges that I recognized and determined in this paper. So the first one is the issue and challenge of the determination of legal assistance recipients. Okay, so as I have mentioned earlier, under the Rule 138A, the rule does not provide for any specific or clear-cut criteria that shall be used by law clinics in determining or screening applicants for legal assistance. And because of this, law clinics has a wide discretion in determining who are the recipients of legal assistance by their law clinics. However, for the first part, A wide array of factors vis-a-vis an applicant's socio-economic status must be taken into consideration. So, for example, uh, we or law clinics may take into consideration the level of consumption or expenditure of a certain individual or family that would take into account the average spending of basic necessities and a certain basket of goods and services that are being availed by the said family on a regular basis. It is supported by one study, and it was found that in developing countries such as the Philippines, consumption or expenditure is the standard measure of material well being because it is better measured than income for poor families. Also, we could also look at the net worth of an applicant for legal assistance and look at the existence of debts, liabilities, and other financial obligations, as well as disposable income of the said applicant. Because no matter how high the income level of certain applicant, if he has um, a lot or an array of existing financial obligations, then it may reflect in the level of disposable income that such applicant has, because income per se and disposable income are quite different matters. Second, nothing prevents law clinics from adapting the combined application of the means and merit tests, as well as considering the other relevant factors that are utilized by the IBP. By the same token, law clinics could also set specific income thresholds to determine their clientele, just like what PAO does. Where the applicant lives. And lastly, other factors that are not directly related to socio-economic parameters must be considered. Um, Harking back to the very purpose of Rule 138A, the intended clientele of law clinics are the marginalized. And it must be noted that marginalization does not merely pertain to individuals' socioeconomic status, but refers to a whole category of people that are excluded from useful and meaningful participation in political, economic, social, and cultural life. So it's a hasty generalization that individuals with a higher than average socioeconomic status could be considered as marginalized as well. So, for instance, persons with disabilities, notwithstanding their socioeconomic status, are considered marginalized on account of their motor or physiological limitations inherent to their condition. In addition, certain ethno-linguistic groups and indigenous cultural communities in the country may be marginalized, notwithstanding their socioeconomic status, due to geographical, cultural, and or logistical factors. That's why it is for this reason that in determining the recipients for legal assistance, non-socioeconomic factors or parameters must likewise be taken into consideration by law clinics. So that's the first issue and challenge. Now we go to the second issue, which is the prioritization of legal assistance recipients. I'll start with the third one, in that law clinics ought not to outright refuse to render legal assistance based solely on applicants' financial capacity. Why? Because under the CPR, as we have discussed earlier, um, lawyers must not refuse to render legal assistance on the basis of the station of life of a prospective client. That's why law clinics must not outright refuse an individual who may afford the services of private counsel. However, due to limited resources, time, and personnel of our law clinics, we need to adapt a prioritization scheme whereby legal assistance clients or recipients are ordered accordingly. So this order that will be established must take into account the tests being applied in the determination stage, no, the socioeconomic parameters. And we expanded those parameters to not only income level per se, as well as the value of property ownership, but we looked at a wide array of socioeconomic parameters to determine with more accuracy the actual socioeconomic condition of a prospective client. Now, law clinics could also gain wisdom from other legal service providers, such as the IBP, that law clinics may adopt the first come, first serve policy, as well as the avoidance of conflict of interest policy of the IBP, whereby if both prospective clients are qualified to be recipients of legal assistance, the first one who sought the assistance of the law clinic may be admitted or may be preferred over the subsequent applicants. However, in the prioritization scheme, there is no hard and fast rule, okay? Unless the Supreme Court would promulgate specific rules whereby law clinics are bound to apply and observe. As things stand, there is no hard and fast rule whereby law clinics may prioritize and determine their legal assistance recipients or prospective clients. Now, with all this, what then can we conclude? The first one is that law clinics are not bound to apply the indigency test in the same manner as courts do. Second, law clinics should consider other factors that may aid them to determine the actual socioeconomic condition and personal circumstances of prospective clients. And lastly, and most importantly, there must be a paradigm shift by law clinics on how we treat and deal with our legal aid clients. We must treat them not just as passive beneficiaries or consumers of legal services, but as collaborative stakeholders in the legal aid process, so that we could share a certain degree of responsibility and obligation to our legal aid recipients, in that they would proactively participate in the resolution of their legal problems. Now, equity is different from equality. As we could see, equity is more about customizing the tools uh, so that the unique problems of each person is uniquely addressed, as opposed to mere equality. And because of that, justice in that way, justice that is offering equal access to both tools and opportunities, may be achieved. So that's all from my side. Thank you, Agyamanak. And may we be conduits of fairness and justice in our respective communities. Thank you very much.
Good afternoon, everyone. Greetings from the City of Pines. I'm Yasmin D. Tadeo from St. Louis University School of Law, and I'm here to present my paper on data privacy vulnerability and legal ethics. The fortification of law student practice by the Supreme Court's revision of Rule 138A of the Rules of Court in 2019 had laudable goals to ensure access to justice of the marginalized sectors, to enhance opportunities of law students, to instill among them the value of legal professionals' social responsibility, and to prepare them for the practice of law. This law student practice required that all law schools should have law clinics which are populated by law students who engage in varying degrees of lawyering. Certain conditions have been woven by the Supreme Court in Rule 138A to guarantee that a lawyer's duty to the courts, to her clients, to the public, and to other lawyers are similarly observed by certified law student practitioners. This includes, for the purpose of limiting the scope of this paper, the duty of ensuring compliance by law student practitioners and supervising lawyers with the Code of Professional Responsibility, and on the part of the school to strictly observe professional responsibility for law student practitioners. and for them to likewise obey the laws as well as the legal orders of the duly constituted authorities therein. Law clinics are staffed and run by law students and monitored by supervising lawyers and law clinic directors. Unlike in traditional law firms, turnover of personnel in law clinics are par of the course and will take place at the end of every semester. After all, law students graduate, transfer to another school, fail to comply with retention policies, or take mental breaks that last months. The same is true for supervising lawyers and law clinic directors. In St. Louis University, the Chief Justice Moran Community Legal Assistance Office is headed by a director who, since its establishment in 2015, have held the position for an average of 2 years. This personnel turnover poses a problem, particularly in complying with the conduct expected of law student practitioners in Canon 21 of the Code of Professional Responsibility and the Data Privacy Act of 2012. This paper tries to investigate if there is a vulnerability that indeed exists when it comes to maintaining and preserving confidences, secrets, and data privacy of the clients, considering the nature and methodology utilized by law clinics. The goal of this paper is to ultimately help law clinics achieve its pedagogical goals for its students by earning and keeping the trust of its clients to serve by not violating the confidentiality of personal information disclosed to law clinics. This is going to be accomplished by conducting two privacy tests. The first one is the privacy impact assessment, and the second is the privacy risk assessment. As part of a lawyer's duty to her client, the Code of Professional Responsibility states that a lawyer shall preserve the confidences and secrets of his client even after the attorney client relation is terminated. To expand on this duty, we take a look at Rule 2104 and Rule 2105 for the purpose of this study. Rule 2104 states that a lawyer may disclose the affairs of the client of the firm to partners or associates thereof unless prohibited by the client. A lawyer shall adopt Rule 2105 states that a lawyer shall adopt such measures as may be required to prevent those whose services are utilized by him from disclosing or using confidences or secrets of the client. The Supreme Court in the case of Attorney Constantino versus Attorney Aranzazo states that the purpose of the rule of confidentiality is to protect the client from possible breach of confidence as a result of a consultation with a lawyer and pressure and preserve the confidential and trust relation which exists between the attorney and client. Rule 2104, as explained by the Supreme Court in Re Mortel, allows disclosure of a client's affairs only to lawyers under their employ. This is different. The concept of confidentiality under the Data Privacy Act is a little bit different. This law has a lofty goal of protecting the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. The law covers all types of personal information, as any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information. This law covers all personal information processed by natural and juridical persons, which including for the purpose of this paper, law clinics. It also covers sensitive personal information, which includes an individual's race, ethnic origin, marital status, age, color, religious or philosophical beliefs, and even an individual's health or education. Data protection further applies to privileged information, which is covered under the rules of court and other pertinent laws. Another important aspect of the DPA is the role of the parties that deal with personal information. First is the data subject. This is the individual whose personal information is processed. For law clinics, the client. The Personal Information Controller is another person who has a duty under the Data Privacy Act. This is a person or organization who controls the information, who controls the collection, holding, processing, or use of personal information, including a person or organization who instructs another person, such as a personal information processor, to collect, hold, process the information. This DPA or Data Privacy Act protects six rights of the client or the data subject: the right to be informed about how the data will be processed, the right to be furnished the information about how personal information is to be processed and stored, to have reasonable access to personal information, dispute the inaccuracy or error in personal information, to suspend, withdraw, or order the blocking or removal of personal information, and of course, to be indemnified for any damages sustained. To protect personal information, its processing must be done with consent of the data subject or when it is necessary as provided for under the law. Whereas processing of sensitive personal information and privileged personal information is prohibited unless permitted by the data subject or when necessary under the same law. The distinction of when it is necessary is found under the law. Lest forgotten, the law specifies the standard for consent to process personal information to be valid. The first one is the data subject agrees to the collection and processing of personal information about and or relating to him or her. This should be freely given. Second, third, it is specific and shows that it is an informed indication of will. And lastly, it is evidenced by a written, electronic, or recorded means. The National Privacy Commission ruled that consent is freely given if the data subject was given a real choice on the processing of his or her personal sensitive personal information. The data subject should not have been deceived, intimidated, coerced into consenting to the act of processing. This was discussed in the case before the NPC entitled BQN versus NUQ Incorporated, wherein the commission determined if there was a compliance with the subpoena and if this is excused under the Data Privacy Act. And in that case, the NPC ruled that the processing and disclosure is permissible, not because it was done without consent, but because it falls under the necessary conditions or those that are necessary for compliance with a legal obligation to which the personal information controller is subject. Let's now move on to what is a privacy impact assessment and privacy risk management. A privacy risk a privacy impact assessment, according to the National Privacy Commission, is an instrument for assessing the potential impacts on privacy of a process, information, system, program, software, module, device, or other initiative which processes personal information and in consultation with stakeholders for taking actions as necessary to treat privacy risk. The PIA has been utilized not only by private entities but is encouraged by government offices in the United States as it is required by the E-Government Act of 2002, Section 208. The Philippines Privacy Impact Assessment is part of the NPC Privacy Toolkit, which is available in its website. It has 12 levels of analysis. Four were discussed in my paper. This is transparency, the collection, the use and disclosure, and data security, including technical security. The privacy risk assessment, which is a test taken after the PIA, endeavors to identify the risk and evaluate its impact and probability. The impact meaning what aspects of the data subject, how much will the data subject be affected, and the probability means the likelihood of it happening. This risk rating after is determined by multiplying the impact of the vulnerability to the data subject and the probability, the chances of something happening. The risk rating is categorized according to whether it is negligible, low risk, medium risk, and high risk. It is determined by multiplying the data attributed to the impact and probability. For the implementation of Rule 138A, a protocol and manual for law clinics was released to provide a background and lay out the procedures for the handling of cases and clients in pursuit of the clinical legal education program, which promotes the concept of learning by doing. The protocol and manual provides for a section on ethics requiring every personnel of the law clinic to adhere to the Code of Professional Responsibility. It further provides that the LSP shall be responsible for the cases assigned to them until such case have been duly turned over to incoming LSPs. A section on data privacy is also provided under the protocols and manuals, which says that the law clinic is committed to protecting the privacy and security of all personal data of all its clients, witnesses, employees, and law student practitioners. Hence, the law clinic shall comply with the Data Privacy Act of 2012, its implementing rules and regulations, and other related laws. This commitment to data privacy is included as footnotes in several of the forms that have been drafted in relation to the protocol and manual. Finally, the protocol and manual requires that the law clinic shall at all times maintain and respect the privacy of persons and protect the confidentiality of all documents and communications, and shall adopt uniform practice and procedure for processing personal data in accordance with the rules of court, CPR, Data Privacy Act, its implementing rules and regulations, as well as other related laws and issuances. Let's now move on to our results and discussion. To begin, the privacy impact assessment based on the template provided by the NPC, it was necessary to look at the data that is being gathered by the it was necessary to look at the data that is being gathered by the law clinics. So on your screens right now is a sample of the information that is collected in the conduct of its business. So for here, this is just a sampling that if what is taken or is provided as an output will be affidavits and letters, the personal information that will be gathered will be the name and address of the client. Sensitive personal information that will also be necessary would be the marital status, the age, government issued identity card number, such as the in compliance with the requirement of the notarial rules for competent evidence of identity, and including the purpose for the drafting of the said document. An example of a case which is taken for retainership, it means that it's going to be a case that is represented before a judicial or quasi judicial body. In this case, this was an ECC case or an Employees Compensation Commission case. What personal information was gathered was the name and address. The sensitive personal information was again the marital status, the age, government issued identity card number, as well as the health of the data subject. This is the minimum personal information obtained from data subjects depending on the reasons for them seeking the assistance of law clinics. What is shown here is that it is undeniable that law clinics collect personal information, process this personal information, which is defined under the Data Privacy Act. The cast of characters in data protection are the law clinics, which is considered as the personal information controller, as it is the entity that effectively collects, holds, and processes the personal information or of the data subject who are its clients, be it walk-in or retained clients, or those entities it serves through public orientation activities. Because the supervising lawyers and law clinic director determines what data is necessary to be processed, they too are considered as personal information controller. Law students who assess the data and information to carry out their functions as law student practitioners are considered as personal information controller as well. This seemingly revolving door of personnel wreaks havoc on six aspects of the data protection: on transparency, storage, technical security, disclosure or sharing, and disposal. In this next slide, this is the result of the transparency test, which is quite relevant in the conduct of the activities of any law clinic. In the CLEP's preliminary interview form, which is available from the CLEP website and is the basis for our own legal office's preliminary interview form, it simply states that I consent to the processing of my personal data for the purpose of facilitating my requests for legal assistance. This, respectfully, is not the consent contemplated in the discussion, which requires specificity, which requires that it's freely given, because it is not specific enough to be compliant with the requirement of transparency. Two questions are relevant in this current discussion. Are data subjects aware of the nature, purpose, and extent of the processing of his or her personal data? This cannot be shown in the preliminary interview form, neither of CLEP's preliminary interview form. Second question: are the data subjects aware of the identity of the personal information controller or the organization entity processing their personal data? This is also not included. And because there is complete turnover of personnel every semester, the law requires that who the personal information controller must be included in the consent form. This should be named. The identity should be named, which is difficult to do considering that every semester the personnel information controller changes. When a new law student comes in and asks or takes information, that name again should be indicated or included in the consent form. Law clinics, if using this consent form, which simply states that I will abide by the Data Privacy Act, they are indeed failing the standards because of the turnover of personnel. Aside from lacking specificity how the personal information will be processed, the preliminary interview form does not specify who the personal information controllers are and how this may change because of the given personnel changes. Neither does the consent section specify that due to personnel changes, personal information may be shared to those who are currently not members of the organization. Furthermore, law student practitioners are reminded to observe data privacy and confidentiality repeatedly in the protocols and manuals and Rule 138. However, based on interview, there is no policy being implemented on the storage of data, the data security, and the disposal of personal information that were obtained physically and electronically, especially in law clinics that require, because of the number of students currently acting as law student practitioners, to form a group to resolve a client's issue. How do the students share that information with one another? There is no policy that governs how they use the information, how they dispose of it, how they can access it. Okay. After the conduct of the preliminary impact assessment is the conduct of the privacy risk assessment. As shown here, I've identified three vulnerabilities. The first two are shown here. This affects the unlawful collection of information. There is a lack of transparency as to the awareness of the data subject, as to the extent of the processing, and the lack of transparency as to the awareness of the identity of the personal information controller or the organization processing the personal data. Reference numbers 1 and 2 as shown on your screen right now leads to unauthorized collection of personal information because of the non-specificity of the information that is provided to the client before collection is taken, which then leads to an invalid consent and unlawful collection of personal information. For reference numbers 1 and 2, the impact is simply limited. Because if the purpose of the legal assistance is for affidavits, the personal information obtained would already be reduced in writing in that affidavit, and it is itself the client who makes the disclosure. For those retained clients with pending cases, if the legitimacy of the use is established, the extent of the how the information is going to be used will be explained as the court proceedings continue, hopefully. The processing would be considered as necessary and the invalid consent could be excused. However, the absence of policies and a specific consent form makes the probability of the happening of the risk almost certain. This is the reason why the probability is 4. Just multiplying it 2 times 4, the risk rating is 8, which is a medium risk to the law clinic. Another identified risk is this one, the unauthorized disclosure due to the absence of policy on storage, data security, and disposal of personal information. The unauthorized disclosure has a significant impact because the client may suffer inconveniences which may be difficult to reverse. The probability of this happening is possible because although the law student practitioners are mindful of their obligation to maintain confidentiality of the information they have obtained, however, if there is no written policy as to storage and access, it still creates an opportunity for improper disclosure. All in all, this three risks poses three medium risks for the law clinics. Excuse me. For my conclusion, these are vulnerabilities that can open the law clinic to suits for violation of the Data Privacy Act. In the NPC Circular number 2201, the penalty for failing to register the true identity or contact details of the personal information controller is around a fine of 50,000 to 200,000 pesos. In addition, the violation of general privacy principles, which is transparency in this case, will be considered as a grave infraction, while the failure to implement reasonable and appropriate measures to protect the security of personal information is considered a major infraction. For these infractions, fortunately, the penalty is a percentage of the annual income of the preceding year. Moreover, the absence of any policy on storage disclosure is a violation of Rule 2105 of the Code of Professional Responsibility, which requires that measures should be adopted to prevent the disclosure or use of confidences or secrets of the clients. As a recommendation, the law clinics must adopt a consent form that contains the specific actions that would be undertaken in processing and sharing personal information, and that should include a provision that says that the current batch of personnel of the law clinic may change in the future. Other matters to make the processing of information transparent should also be included in the consent form to make the collection and processing of personal information lawful. This would then remove the risk identified as reference numbers 1 and 2. Policies should be adopted to identify where personal information should be stored, both for digital and paper copies. The policy should limit how law student practitioners access personal information and sensitive personal information should it become necessary to collaborate with one another in assisting a client. The policy should include a provision on how long personal information should be retained and how it will be disposed of. This then removes the identified reference number 3, the risk that is shown on your screen. Concomitantly, the drafting and enforcement of a policy on data security creates a better right to hold the law clinic director, supervising lawyers, and law student practitioners accountable in case of an unauthorized disclosure. By adopting such policies, any violation should be considered as an aberration and not the culture of the law clinic. Finally, more people have become mindful and zealously protective of their informational privacy. If the goal of Rule 138A is to be achieved, clients must be able to rely not on mere promises, but on clearly worded policies that their own lawyers will process the relevant personal information according to what they have consented to and only for legitimate reasons. Otherwise, the dream of access to justice and experiential learning would remain a vacuous imagination marred by distrust and policy failure. This is my paper. I think the floor is now open for questions. Thank you very much.
Hello once again. So, if there are any questions from our online participants, we highly encourage for all of you to ask them now about my paper as well as Attorney Tadeo's paper. So, you may likewise type in your questions in the chat box, and our hosts may ask the questions to us. If nahiya kayo, i-ask directly. Okay, we have one.
There is one question, if I may. Did your study consider the privacy management program of the college or university as the default in absence of a law clinic specific program? Um, this was taken also into consideration, especially since St. Louis University is just now developing its own data privacy policies. However, the law requires that it should be there should be a process information controller. And the process information controller here is not the university or the school of law for that matter. It is the law clinic itself, which is acting as its own entity. So it is best that it is the law clinic itself which develop its own data privacy policy that is proactive in making its own consent form that is compliant with the provisions of law. I hope that answers your question, Mr. Burnagan. Thank you.
Any more questions from our online participants? All right, there's another one for Attorney Tadeo, I think.
Okay, sorry. Considering RA 10173, do we need to amend its IRR or even the law itself in order to address some gaps in enforcement and other penalties vis-a-vis certain instances not fully covered by law in certain instances? How can CLEP perhaps help address this? Um, I think with all our laws, it's a finely crafted law. The Data Privacy Act is a good law. The implementing rules and regulations is a good law. Even the penalties that was just released under NPC by the NPC is a good provision of law. It's always the enforcement that is necessary. Um, Especially since our own Data Privacy Act is based on a model law. So I think it's not that. It's again the enforcement. CLEP can do this by being the first to make sure that our clients are compliant, that the data privacy of our clients are protected. There's a question for you, Attorney Josiah.
Ah, yes. Thank you, Attorney Tadeo. So good afternoon po, Attorney Josiah. Is it true that the IBP does not accept estafa cases, sorry, even if indigent? All right. So, Miss Pagyo, so as earlier discussed, the rules that govern the acceptance and handling of cases by the IBP, we have the means and the merit test. So, under the merit test, even if a certain applicant for legal assistance who went to the IBP is an indigent, however, if under the merit test, which involves the ascertainment of the applicant's cause of action, no? Whether there is a valid defense or whether there are chances of establishing that cause of action in court. The IBP and its various legal aid offices may take that into consideration. Okay, so as I said earlier, there's no hard and fast rule because, of course, different IBP local chapters and their legal aid offices as well may ascertain the merit may apply the merit test, and they have discretion whether according to them there is merit to the cause of action of a certain applicant. So in your question, estafa cases, so it depends. I think that if from the perspective of a certain IBP local chapter legal aid office, that applicant has no cause of action, then I think the IBP may refuse to deliver legal assistance. So that will be all. I hope I answered your question. All right, thank you.
Thank you, Attorney Tadeo and Attorney Bagayas. That concludes the session for this afternoon. So this room will be closed by the host shortly. What will follow is the plenary session on lay of the lands and the needs assessment study conducted by the Association of Law Students in the Philippines and the Philippine Association of Law Schools and the Asia Foundation. So to join the plenary session, please go to your schedule tab and access the plenary scheduled at 2:45 p.m. Until then, you may take your virtual break. Salamat po.
Thank you.